these are part highly closed in the matter of HMRC applicants in the post-prudential closure notice agreement and announcement.
Yes, Mr. Brown.
Very grateful. Now, please can I start by dealing with three of the questions that came up yesterday. The first concerns the status of the Charter, and we've done some further research following some of the exchanges yesterday, and we think the position is this, that the Charter is applicable in relation to these appeals. I'm afraid I seem to be the only person in the courtroom who has a tabbed version of the three sections that I would need to actually show the court. But could I just tell your lordship what the sections are, and then we'll supply you with a tabbed version of the provisions at the short adjournment, if that's all right.
All right.
So section 5 sub 4 of the EU Withdrawal Act 2018 tells you that the Charter is not part of domestic law on or after IP completion day. So that, of course, is 31 December 2020. But then one has to go further, and there are provisions contained in Schedule 8 to the 2018 Act on consequential transitional, transitory and saving provisions, in particular in Part 4. Part 4 is given effect by Section 23 sub 7, and within Part 4 it's paragraph 39 sub 3 within Schedule 8, and that tells you that Section 5 sub 4, which is the provision that would have turned off the Charter, that does not apply in relation to any proceedings begun but not finally decided before a court or tribunal in the United Kingdom before IP completion day. And in this case, the appeals and applications were all begun before IP completion day.
When were they begun?
It varies, my lord, but I'm told in all cases prior to 31 December 2020. And if I may, I'll provide those provisions in a format that actually we can easily follow. We've got
okay.
It here. So I hope that deals with that point. The second point is the extent of overlap between claimants in Class 8 and in these proceedings. And may I give the following quite general answer? There is significant overlap, but there are some taxpayers who are party to these proceedings, certainly at least in the stayed cases, who do not have High Court claims, and there are some claimants in Class 8 who are not parties to these proceedings. And then the third question was the commencement date for the 4-year time limit in paragraph 51. That is the 1st of April 2010, subject to transitional provisions. That was done by Finance Act 2008, and that's noted, and there's a reference to the statutory instrument with the transitional provisions. I don't think anything turns on it in the authorities bundle at electronic 155. So I hope that deals with my Lady Justice Falk's question. It simply notes a forthcoming amendment, so the amendment itself isn't in the bundle. If the court would like to see it, we can of course provide that.
Okay, so because it's 1st of April 2010, it's actually only when you get to the rewritten. That's also the date when the
rewrite came in. That would be right.
So at all, the version of Para 51 that's relevant for this appeal. So do take it.
Sorry.
Do pause.
I'm very sorry.
The version of Para 51 that is relevant to this appeal, therefore, at all times had a 6-year time limit.
And is the version in tab 11 in the authority.
Thank you.
And so I hope that deals with those 3 points. I was proposing to complete my submissions on the general matters very briefly by dealing first with Class 8 and then
Can I just come back to what you were telling us about the charter? Because will need to be satisfied as to chronology, because I just glance at Court Bundle 2 and notice that some of the decision letters which are under appeal are issued in 2020. And for example, I see that there's one in a case called Henderson, dated 25th September 2020. Now, it may be the case that an appeal was filed against that decision before the 31st of December 2020, but equally, how do I know that?
Yes, well, Lord, in Henderson, I mean, the checking that's been done, my instructions are everything was filed before 31 December 2020.
Right.
Dealing with Henderson, there are 3 appeal letters in the supplementary bundle, tabs 37 to 39, and they are 22 May 2020, 16 October 2020, 6 November 2020. But perhaps the easiest thing is simply if I'm very happy for them to produce a table with the dates, if that would help your lordship.
Okay.
So
Those are appeals to the revenue. Rather than
That's true.
appeals to the
And the- and-
rather than the appeals being referred to the tribunal.
And we don't have the notifications to the tribunal in this court's bundle. It would all be in the papers below. But to the extent we need to,
yeah, but this is important because at the moment, subject to further elucidation and education on my part, because this is my ignorance, let me be clear, I would assume, and I may be completely wrong in this assumption, that the relevant date is the date of the appeal to the FTT.
that would be right, my lord, yes. And all I can say to the court at the moment is I asked for the point to be checked, and I've been told that all the appeals were filed or closure notice applications made to the FTT prior to 31 December 2020. That's the best I can do at the moment.
All right, thank you.
If your lordship would like to see the underlying materials, I'm sure they
No
can-
doubt
they can
Mr.
be
Hewitt's
provided.
team can
I'm sure
confirm
that's also right.
or otherwise.
But what I can't do from memory is
Sure.
tell you what was in the bundles below. Can I deal very briefly with Class 8? This is picking up the points we make in the appeal skeleton, paragraphs 10 and 19 to 21, where we say that the Upper Tribunal went wrong. This is particularly its paragraphs 135 to 137. The court will recall the tribunal looking at what the Chancellor had decided in Class 8 and essentially saying that the reliance that the taxpayers placed on the supervening principles couldn't stand with that judgment. Now, Class 8, of course, it's under appeal to this court. It doesn't bind this court. My preference is to focus on the substantive arguments.
Okay.
And I'm either right or wrong, but I say 2 things about Class 8. The first is it's dealing with a different issue and the context is very different. And the second is that this is particularly Class 8, paragraph 83. It was either wrong or one has to be very careful about taking out of context the Chancellor's observation that claimants must be deemed to have known since 2006 that a Section 790 claim is
Sorry.
available.
Can
Yes.
we have a
We
look
need
at
to
this?
look at the-
Oh, I'm very sorry.
Where is it?
Of course. Class 8 is Authorities Volume 4, tab 45. Starting at page 1207. And as I say, dealing with a different question, which the UT in effect acknowledges in 135 to 137, but they say that doesn't matter. And the thing I particularly focus on, that it either goes too far or it has to be looked at in the very particular context that the Chancellor is deciding, which is not this context, is paragraph 83, which I'll show the court in a moment. That's page
So what's
1251.
wrong with paragraph 83?
Well, the problem with paragraph 83 is that in my submission, what it does is it rewrites history. It takes the declaratory theory too far. When it says, particularly at the end, that claimants must be deemed to have known since 06 such relief was available. And then in 84, that the relief allowed isn't prevented from being an effective remedy because it only applies as a result of mar leasing. Well, that might be right if one's simply looking at the effect of the declaratory theory. But what one needs to look at here is the effect on actual steps that were taken at the time. And the submission I was making yesterday is that the conforming interpretation cannot be used to undermine steps that were reasonably taken at the time to vindicate EU law rights.
There's two different questions, aren't there? I mean, I understand your point about deemed knowledge, and I can quite understand an argument that says the fact that a conforming interpretation has been adopted can't possibly affect the knowledge of people. They knew what they knew and they didn't know what they didn't know. And the fact that a conforming interpretation of the statute is adopted subsequently can't affect that. That I can understand. But it's a different question, isn't it, whether upon an objective assessment, steps are taken which comply with the statute once properly interpreted.
Well, my lord, that's why in my submission I was making the distinction. I showed the court yesterday FI Court of Appeal 1, which contemplates this, that that there is a difference between how may one read the statute. This was 107 and 103, I think, in FI Court of Appeal 1, where this court contemplated that there may have to be a further inquiry and further examination as to what one needed to do with procedural rules in the light of the conforming interpretation. That's why I'm submitting.
But then we come back to the point that was debated at some length yesterday, and I will just raise the point for one last time. I hope I will try and be quiet about it thereafter, which is, I think at the moment, one needs to distinguish between the question of statutory interpretation and other procedural remedies, which at the moment don't seem to be an issue. So there is the question of, do you comply with the statute as properly interpreted? And that is a question of applying the proper interpretation to the objective facts. There may well be other questions that could potentially be raised, such as the availability of public law challenges, legitimate expectations, etc., etc., etc. But none of that, as I understand it, is before us. We are, as I understand it, and tell me I'm wrong, concerned purely with the question of, here's the statute, we've got to interpret it and then apply it to the objective facts.
Well, we're looking at the validity of statutory claims. Yes, that's right. But the submission that I was making yesterday, which I maintain, is that the conforming interpretation and its application, that has to be applied sensitively to the general principles of law, including effective legal protection and legal certainty. And that's why I part company from the summary that your lordship just set out in saying that the starting point is here, well, we have the conforming interpretation, then it's just a question of how that then feeds through as a matter of objective fact. My submission is there is a further inquiry in these appeals, which is that very black and white application of conforming interpretation, is that consistent with the general principles of law?
Well,
and that may require.
if you frame it in that way, let's take the hypothesis, suppose you're right. Let it be assumed that that the conforming interpretation applied to these facts is inconsistent with general principles of EU law.
Yes.
What is the consequence?
Then one of two things have to happen. Either one must revisit the conforming interpretation,
But I don't understand you to be inviting us to do that.
no, or one needs to look at knock-on effects on the procedural conditions.
But what does that mean? When you say look at the knock-on effects on procedural conditions, what does that mean?
Well, you have to ask either whether, take standard life as the example, does one construe the claim provisions, and there's very little in the way of actual claim provisions. We've got 788 sub 6, 806 sub 1, and para 54 saying the claim needs to be quantified. And you would have to say either, as a matter of construction, does what standard life did answer to the requirements for making a statutory claim, or alternatively, does it answer to the requirements of a para 51 claim with those procedures construed so as to give effect to those supervening principles. That's the requirement. The court is required to consider the procedural rules and interpret them in order to promote the effective legal protection of these taxpayers' rights. And I don't understand there to be any challenge about that as a principle. The question is, what does that involve in this case?
Grandma, I don't know if you were going to cover it. Are you going to discuss what Jazztel in the Court of Appeal had to say about Class 8?
On hidden retrospectivity, I wasn't proposing to.
Right, well, I mean, for me, it raises the question as to whether you say Class 8 is wrong on this.
Yes.
We shouldn't follow it, but at least some element of this has been approved by the Court of Appeal in Jazztel.
What was approved was the discussion on hidden retrospectivity and how Section 320 works. That was
in fact, they disapproved
Yes.
what was said in relation to Section 320. My reading is they approved what the then Chancellor said about hidden retrospectivity in other respects.
Yes, but what we're dealing with here is not a problem of hidden retrospectivity.
Is it not?
My submission, no, it's a much more. This is not a. The problem we have here is people who took steps in accordance with the time limit that applied at the time. The problem that Mr. Justice Marcus Smith had identified was to say you might end up being timed out without knowing that you had a right.
This is a variation on that theme.
I submit it's different, my lady.
Well, before you develop that argument, can we take a brief look at Jazztel? Because I don't have the familiarity with that decision that my lady does. So if we could just have a quick look at it, please. And indeed, of course, Sir Launcelot.
So, well, tab 49. It's tab 49 in the authorities, which is volume 4, starting at 1381. And I think the discussion of Class 8 starts at paragraph 72. But these were common law claims for a whole series or the return of a whole series of payments of stamp duty reserve tax. And looking at the head note, all but one of them had been made more than 6 years prior to the issue of the claim form. And so the claimants needed Section 32(1)(c) of the Limitation Act 1980. And the discussion of Class 8 starts at paragraph 72. And 75 is what the Chancellor had said about hidden retrospectivity. said, well, the knowledge of the claimant as to the existence of a claim is nothing to the point. And then there was a question, because Section 320 had been introduced without transitional provisions, there was an issue about could it be applied to causes of action which had accrued, well, say, could it be applied to events that happened after it was enacted, notwithstanding the absence of transitional provisions. That was the point where the Court of this Court overruled the Chancellor.
Yes, I'm not focusing on that.
No. But I'm very similar. I'm not sure what passage it is that's going to help us here.
Go to, so as I understand it, the hidden retrospectivity is you didn't know your rights at the time.
Yes, and
you had an opportunity to assert them, and as Justice Martha Smith.
Yes, but the point is that's looking at a case where no claim was made.
But this is a variant on that, is it not? The case against you is it didn't matter that you didn't know the precise form of the infringement of EU law. You were still stuck, as it were, with the infringement as subsequently interpreted. Yes. So if you go, for example, to paragraph 80,
yes,
I think it comes back later. Page 1 2/3 down. Our own conclusion is that Sir Geoffrey Voss was entirely right to reject the espousal of hidden retrospectivity. 80.
Yes. Oh yes, as will appear our own conclusion.
Yes. So that summarises. They say he was right to reject the concept of hidden retrospectivity, but wrong on
how he dealt with 320. Yes.
Well, I'm not concerned, I think.
No, I understand that, lady, but my answer is that what that does not deal with is a situation where the manner in which a claim should be made is unclear, and in which a claim was actually made. Because what Mr. Justice Parker Smith and the Chancellor were dealing with when they were talking about hidden retrospectivity was a claim that was made outside the time limit that would have applied if Section 320 was good.
So you draw a distinction between no claim at all.
Yes, and the claimants doing their best to assert their rights using the statutory procedures that reasonably appear to be available at the time.
Can I just ask a question about that based on what's said in paragraph 94 in Jazztel, where the revenues submissions are rejected because, as it's put, they treat the continuing ability of Jazztel to make the relevant claims after 8 September 2003 as conclusive, whereas the real problem is a structural fault in the legislation which cannot be cured unless and until adequate transitional arrangements are put in place. Till that's done, Section 320 must be disapplied. Now, my question is this: am I right in understanding that you are not inviting us to disapply any of the legislation with which we are concerned?
No, I'm saying we don't need to get to that. That's right. If it comes to ultimately what there needs is to be effective legal protection for these taxpayers' rights. If that requires disapplication there would need to be. But my submission is we don't need to do it, because when we look at the claim provisions, one can get there. If one can't get there, then there may need to be a different solution.
For completeness, Mr. Bramley,
Yes.
I took you to the summary at 80. I think they come back to it at 89.
But what's being looked at there is of the right to make a claim. So
Yes, no,
so
I
there's
see.
there's a difference between not knowing that you can claim for tax unduly levied on dividend, the limitation period expires. It then emerges you can make such a claim. You say, I didn't know I could do this. I'd like to claim now. They say, no, the time limit applies. That is a completely different situation, in my respectful submission, from a circumstance such as arises in the cases that we're concerned with at this stage of the appeal. These taxpayers did know, or they thought, there was a breach of EU law. They were asserting their EU law rights. They were trying to assert their EU law rights. They were trying to get in front of the court to do that. That's not the situation that was being dealt with in Jazztel, and there is a very significant distinction of principle in my submission between those two situations. And I go back to the example that I gave yesterday. Suppose, take Standard Life and its paragraph 51 claim. In my respectful submission, it is not a credible analysis to say that if that claim had in fact been the test case, so if the way in which that issue of compatibility with EU law had been ventilated was through a statutory claim like the one that Standard Life brought, it cannot be right that the court would have gone through all the analysis of saying, yes, there is a breach, there's no justification or it's disproportionate, so there is a breach of EU law, the UK provisions don't comply. Let us now look at the appropriate relief. We will do a conforming interpretation, and the result of that is, I'm terribly sorry, your paragraph 51 claim failed to meet the relevant statutory conditions, and therefore you get no relief at all. That's, if my friend is right, that's what would have happened if Standard Life had been taken as the test case. And it cannot be right that by virtue, if you like, of some accident of history, so the fact it was common law claims for restitution, and I showed the court, this was paragraph 106 in Prudential High Court, and it was paragraph 77 in Prudential Court of Appeal 2016. The difference in that case between disapplication and conforming interpretation, or indeed different types of conforming interpretation, made no difference in the Prudential case. We are now dealing with a case where it makes all the difference in the world.
Okay, thank you, I understand.
And that's why I say we don't get any help out of Jazztel. The two general points I wanted to just touch on, and then I'm going to deal with the issues in, I hope, a sensible order. The first is the point we make at paragraph 34 of the skeleton, that the Upper Tribunal's decision fails to give any or any sufficient weight to the fact that the UK statutory provisions, as originally enacted, breach EU law. True it is, there is a conforming interpretation. True it is that legal theory in this jurisdiction is that a conforming interpretation is recognized.
Sorry, you say in this jurisdiction, but I thought we went over this yesterday. The Court of Justice has decided. It's not merely this jurisdiction.
Well, conforming interpretation is something that the courts of this country have to deal with. That's why I put it in the way that I did. I'm not saying it's some peculiar English thing. The point I am making, though, is that if one is looking at the history of this in a realistic way, it would be wrong to say that there wasn't an unlawful requirement to pay the tax. And I said yesterday I would show your Lordship the tailpiece to what Lord Sumption had said in FII immediately after the passage that was being quoted in Prudential about the retrospective nature of conforming interpretation. And there's also a short passage I need to show you in the speech of Lord Walker. And that is in FII Supreme Court 1. Authorities Volume 2, tab 28. Passage that was quoted in Prudential is in Lord Sumption's judgment, paragraph 176 at page 675. That's highly muscular approach. And the deemed to declare the law retrospectively point. Can I just go back half a step to look at the context in which that observation was made? You'll see that in paragraph 170. At the bottom of 672. And this was one aspect of a number of submissions that the test claimants were making to say that the Woolwich cause of action wasn't available. And it was their second point that Lord Sumption was dealing with. And that was to say, you can see between B and C, that applying my leasing, well, there's been a conforming construction, so therefore there's nothing unlawful about the section under consideration. That's what's being responded to in 175 and 176. You see it's headed up the my leasing point. He's already dealt at that stage with what he called the demand point. 175 notes that we've got the conforming interpretation, and then you can see the claimant's argument recapitulated at the end of 175. And then it's the remainder of 176, and notwithstanding that retrospectivity, it doesn't follow that there wasn't at the time an unlawful requirement to pay the tax. And then that's explained in the remainder of 176. And can I just show you a similar point made by Lord Walker, and then can I make a submission about this? Lord Walker deals with the same point at paragraphs 82 and 83. And the argument is summarised at 82, and then its rejection is in 83, and it's on the basis that it seeks to rewrite history. It's put in slightly different terms to what Lord Sumption had said. So that's how it's being dealt with, and that shows in my submission that one has to be careful about how far one takes the logic of the retrospective nature of the conforming interpretation. That, of course, is being said in the context of a Woolwich claim, but as I was explaining yesterday, that line of reasoning in my submission must apply equally in the context of a mistake claim. We know, and we saw it in Prudential, that the fact there was a conforming interpretation didn't prevent the mistake-based claims from being made. And that's notwithstanding that if one takes to its extreme logical conclusion the conforming interpretation in Prudential, it would be to say, well, the UK legislation always provided for the right to claim the credit, and Prudential didn't claim the credit.
I don't think you need to go that far, because the conforming interpretation indeed shows there was a mistake in filing the return. That's what we're looking at here.
Well, but if that's right, that must equally follow. That must equally follow for these statutory claims. The mistake can't be different.
I'm thinking about paragraph 51.
I'm so sorry.
I'm thinking about
Yes.
paragraph 51.
Yes.
The mistake you
Yes.
say is in the return.
Yes, that's right.
It was a mistake as compared to the conforming interpretation. You say.
Yes, indeed. But sorry, I was making a slightly different point about Prudential, because in Prudential one had to identify the unlawful tax, and there was still unlawful tax, even though there had been no claim for credit. That was the only point I was trying to make about Prudential. So I'm showing the court those passages because it shows that one has to be sensitive to what the history actually was. And then the second point, and then I will deal specifically with the issue, starting with issue 2, is the point of paragraph 36 in the skeleton. When we look at these issues, particularly issue 2 and issue 5, one has to bear in mind that the claim for double taxation relief by way of credit at the foreign nominal rate, that is equivalent to the exemption basis that was originally asserted. And I showed the court yesterday the passages in Prudential High Court, it was para 92, about the foundation of the analysis being that the foreign nominal rate credit and the exemption are regarded as equivalent. and that picked up on what the Court of Justice had said in FIICJ 2 at paragraph 61. So we're dealing with two matters which are conceptually similar and which serve the same purpose, and that in my submission is relevant when one comes to analysing the claim documentation. I'm going to deal now with the issues, and I can deal more shortly, particularly with issues 2, 5 and 9, because I'll be adopting the general submissions that I've made. Can I just very briefly say a word about issue 1, which is common ground, but it's important not to lose sight of the fact that although the outcome is academic, because the claimants affected by issue 1 get relief, that's Upper Tribunal 74, and also FTT 116 to 117. It is important just to remember what that's dealing with. That's where the taxpayer filed his return or amended in time onto an exemption basis. And what the revenue says in those circumstances is that the return is wrong, the dividends are taxable, but then the adjustment to the return that the revenue makes, that triggers a further opportunity for the taxpayer to claim credits under section 806(2). And that's why I think yesterday I said, well, actually it's happenstance that a taxpayer gets relief in those circumstances. The taxpayer isn't in any direct way getting relief as a result of the original exemption filing. It's essentially good fortune that the way the UK procedural provisions work is that there's then an opportunity later to make a claim. As I say, I'm not going to take up time with this issue, it's common ground, because for those taxpayers it doesn't matter, they get their money back. But that is something to bear in mind when we look at the other issues. Issue 2 is the para 51 claims, and I've done most of this already. We saw Standard Life as the test case. We looked at its paragraph 51 claim supplementary bundle, page 41. We know that was made within the limitation period applicable to paragraph 51 claims, and I showed the court yesterday what paragraph 51 says, and in terms of the formal requirements, there's very little in the way of formal requirements. There's no requirement on the face of the legislation to do anything other actually than quantify the claim. I've got.
Well, in fact, this is a mistake. It's not a claim, so it's not strictly covered by. I'm not sure you even need to.
Perhaps that may be right because
You're thinking of para 54.
I am, but it may be that one doesn't even need that. I've got four broad points under issue 2. The first is that para 51 claim, that is effective as a para 51 claim to recover the unduly levied tax. The second is if a paragraph 51 claim doesn't work and there needs to be a claim for credit, then that letter that Standard Life wrote, that can take effect as such a claim, because it can be characterised as such a claim. Third, if I'm wrong about that, section 114 of the Taxes Management Act will validate the claim. And then fourthly, if all of that's wrong, the Standard Life will get home applying the supervening principles of EU law. So the first point is to deal with
just can you give us a heads up as to what that means? Because I'm still struggling with that. I mean, the first 3 points are conceptually clear to me, and,
yes.
and you know, if you're right on one or more of those, then this point doesn't arise.
Yes.
So we assume for this purpose that you're wrong on the first 3 points.
Yes.
And you say, aha, I've got this magic wand. It's called supervening principles of EU law. Now, let's assume that you're absolutely 100% correct as to what those principles are.
Yes.
I'm still struggling to understand how you say that they get you to the result.
Because the court, if those principles are engaged with an otherwise non-compliant claim, the court would have to look at the requirements of the domestic procedure So, for example, the Upper
But
Tribunal.
I'm sorry to interrupt, but
Yes.
what's the juridical mechanism that you're employing? I mean, you've already confirmed what I thought, which is you're not saying we disapply paragraph 51. So the question is, what are we doing?
So I say that what the court would be doing is complying with an obligation to interpret its procedural rules.
But this isn't a procedural rule, it's a statutory claim.
It's a procedural rule in the sense that's used by the Court of Justice, because a statutory claim would answer to the Court of Justice's categorisation of a procedural rule.
Yeah, all right, I'm sorry, I'm obviously failing to make myself clear, and it's my fault. The question is, how do you say the principles achieve the result? So there are possibilities. So one possibility would be you need a conforming interpretation of paragraph 51 itself.
That's one.
Another possibility might be disapplication of paragraph 51. There might be other possibilities, such as you've got a claim,
Yes.
such as a Frankovich claim. I mean, there are all kinds of possibilities as to how these supervening principles can be applied. And what I'm asking for is precision as to how you say we should apply them in this case.
Let me just first of all try and help with the source of the obligation. If the court has the First-tier Tribunal's decision, core page 282. This is the core bundle, page 282. And it cites from the Unibet case. And the obligation I'm relying upon is the one that is set out by the Court of Justice in paragraph 44, which is within 78 of the FTT's decision, top of page 283. And it's the obligation on the national courts to interpret the procedural rules governing actions brought, in that context, governing actions brought before them, in such a way as to enable those rules, wherever possible, to be implemented in such a manner as to contribute to the attainment of the objective of ensuring effective
I have
judicial
absolutely no problem with that
Right.
principle whatsoever. But that principle involves the following steps. First of all, you identify the national procedural rule.
Yes.
Thirdly, secondly, you identify the respect in which it is prejudicing effective judicial protection. Thirdly, you then say, okay, how do you need to adapt that procedural rule in order to ensure effective procedural protection? So that's the analysis.
And in this context, take the paragraph 51 claims. I've lost on the basis that there was no mistake. And I've lost on the basis that if there was a mistake, it was a mistake in a claim. And my submission, if we're on submission 4 at this stage, is that those requirements would have to be subject to a conforming interpretation such that in these circumstances there is a relevant mistake and it's not barred by para 51 sub 3 sub B.
Right, so it comes to an argument, which is to me an intelligible argument, about the meaning of the word mistake.
Yes, no, that's true. In that context, yes. Because one has to work out why it is that the claim has failed. And I would equally say that similar principles could be applied in the context of section 114.
All right, thank you.
I was dealing with para 51 just as a para 51 claim. I think I've actually dealt with these points yesterday because the Upper Tribunal said, well, there's no mistake. And I've made my submission, well, there was a mistake in the return. It's a mistake about the basis upon which as to the compliance of the UK provisions with EU law, and I also made my submissions as to why the exclusion in para 51 sub 3 sub b couldn't apply. It wasn't dealing with a mistake in a claim. That wasn't an apt way of characterising the mistake in this case. So unless I can help you further on those points, I was going to adopt what I'd said yesterday.
Can I just check I've understood correctly?
Yes.
As I think I understood your answers to my lord's questioning, you were effectively arguing for a kind of what yesterday I referred to as a sort of ancillary or second stage, second tier leasing as applied to the procedural regime which is there in the legislation once the primary breach of community law has been established by a conforming construction.
One could look at it in that way, yes. Or one might say, well, now that we know about circumstances like this, one has to look back at the conforming interpretation that was established in Prudential, because those matters were not before the court at that stage. So whether one says this is a more sophisticated conforming interpretation of a general nature, or whether it's a stage 2, you should get to the same place. But what one must do is take into account the effect of the conforming interpretation on these particular claims. I also have to be careful because I'm doing this in 2 stages. I'm saying, first of all, that this is good as a para 51 claim, just looked at in the context that we're dealing with. And then I've got a second stage of saying effective judicial protection. Second submission is to say that that letter, if there needs to be a credit claim, that letter is capable of taking effect as a credit claim. And I rely here really on the absence of any formal requirements other than the need to quantify the claim. I fully accept, we looked at it yesterday, that the letter doesn't say credit. The letter doesn't say section 790. So if this court says, in order to claim credit, you needed to give the section number, I lose. If this court says, in order to claim credit, you needed to use the word credit, at this stage of the argument, I lose this submission. I recognise that. But what I'm saying is that looked at in context, what this letter was doing was asserting Standard Life's right to free movement of capital and saying that the UK provisions breached that right. We now know that the content of that right was actually there was an entitlement to a credit. Looked at in context, and that letter is a demand made of the revenue actually for repayment. Looked at in context, credit and exemption, they are equivalent and they serve the same purpose. And that's why in my submission one can say, if you're asking what's this claim intended to achieve, it's intended to achieve the result that the taxpayer obtained the reimbursement of the tax that had been overcharged. We know now, of course, that right is to be given effect through the conforming interpretation of section 790, providing for the additional credit. We know in section 793 sub 1 that what credit does is it reduces the amount of UK tax chargeable. And that's why at this stage of the argument, I characterise the credit claim really as machinery. The Upper Tribunal itself recognised that the labels aren't determinative. That was paragraph 103 of its decision. That was common ground. And I do say, looking at this letter in the context as it's now understood, and the court said to me many times, well, this conforming interpretation, it's retrospective. If we really are going to live in that world of retrospectivity, that must have a role to play in understanding what, if anything, is the effect of that letter. So that's the second route. And then the third route is section 114 of the TMA, which I haven't shown the court yet. That is in the authorities, volume 1, tab 3, page 13. And there are various different kinds of proceeding identified: assessment, warrant, or other proceeding. And we'll see, as a matter of authority, other proceeding, we're told in a case called Archer, takes us back to 113 sub 3 at page 9 and includes other documents required to be used in assessing, charging, collecting and levying tax. And this is essentially a saving provision. So such a document is not to be quashed, deemed to be void, etc., or affected by reason of a mistake, defect, or omission, if the same is in substance and effect in conformity with or according to the intent and meaning of the Taxes Acts. And then there's a requirement that the person or property, in my case it's affected thereby, is designated according to common intent and understanding. And in my submission, if we get to this stage of the argument, what's happened is either that there's a mistake or a defect or an omission in Standard Life's letter, in that they've asked for the wrong thing, or they've failed as a step to say, we want our money back, but the first step to getting our money back is getting a credit.
So there must be learning on how far this provision extends.
There is some, and I'm going to show the court that. But I'm bearing in mind, or I'm asking the court to bear in mind when it looks at this provision, the point I was making a moment ago about the equivalence between credit and exemption, and the fact also, and two other points, that ultimately this is all about, one way or another, getting a repayment, because the credit is just a route to a reduction in tax chargeable and therefore a repayment. And the fact that the credit and exemption analysis in this case, and indeed in almost all cases, give you the same answer. Now, what the Upper Tribunal said was, well, this isn't the kind of defect.
Sorry, just on that.
Yes.
When you say in almost all cases the same answer, that assumes that the foreign national rate is generally equal to or higher than the UK.
And it almost always is.
Was that established? There was no finding of that.
There's no finding, but there's no dispute that in Standard Life's case you'd get a different answer on the numbers. The reason for that is that in working out the amount of the case 5 charge, the withholding tax comes off first. There's some discussion of this actually in Prudential High Court.
So it's taking account of the withholding tax, the FNR.
Means you need very little in terms of difference.
Okay.
So the Upper Tribunal said essentially that the mistake would be gross or fundamental and it would have misled a reasonable officer. That was Upper Tribunal 121. And that was under reference to 2 cases, Donaldson and GLL. And both of those are distinguishable in my submission from this case. Donaldson is in Authorities Volume 3. It's tab 35, page 897.
Sorry. I don't mean to be picky, but it seems a bit odd to take us to authorities which you're going to distinguish. I mean, I would have thought the starting point would be an authority which tells us how far section 114 goes, and then for you to be relying upon that authority. Maybe that's a bit simple-minded.
Well, I'm happy to do. Well, one gets a sense of the breadth of 114 if one looks at Archer. So let's look at that. That's tab 39, end of volume 3. This was about section 114 validating the terms of closure notices. and 33 under reference to Craven and White. There's a description of what section 114 does. And we're dealing with a right of the document in question treated as if it had been in the correct form. And what's of some importance, because my friend takes in his respondent's notice a point that 114 can't apply to documents provided by a taxpayer. Well, actually, if one looks at what's said about Craven and White, the right is given to G, HMRC or the taxpayer as the case may be. So there can't be any doubt that this can apply to a document that's provided by the taxpayer.
Well, that's not quite what this is saying. It says either side can rely on 114. I don't think it's authority, is it? For saying that it applies to taxpayer.
It'd be very odd for the it'd be very for the taxpayer to be saying if it shan't be affected.
Well, this brings me back to what I was saying about learning on section 114. I mean, let me ask the question in a different way since we've come on to the respondent's notice point. Is there an authority which establishes that section 114 does apply to taxpayer documents?
The closest one can get is the McGuinness case, which is referred to in paragraph 34 by this court in Archer. It's only first-tier tribunal, so it's of no binding effect. But what that case does is it has as a step in its reasoning that a self-assessment return is a, quotes, other proceeding. So perhaps I can just show you that in McGuinness. That's Authorities tab 29, which I'm afraid is the last one in volume 2. The ultimate issue in McGuinness is actually a slightly different one. It's whether a notice to file issued by the revenue can come within 114, that it's a step in the reasoning that a self-assessment return is a, quotes, other proceeding. And this was before the Court of Appeal in Archer, as you can see from paragraph 34 of Archer. The easiest thing is probably to pick it up at paragraph 52. That's after having referred to 113. And that's the point that's picked up by this court in Archer, paragraph 34, that the draftsman's using other proceeding as shorthand for the list of documents in 113. And then 54, if that's correct, then a essay tax return. It's not actually defined by the tribunal, but it must be a self-assessment tax return. That would be an other proceeding, as it's a document required to be used in assessing tax. And then a notice to file, which was the document at issue in that case, that takes the place of an essay return for those who are expected to file online. And then it said if it's correct that an essay return is an other proceeding, it must also be correct that a notice to file such return falls within section 114 sub 1. The Upper Tribunal in its decision said, no, McGuinness doesn't help you because that was about a notice to file, but it overlooked in my submission the point that the way in which that conclusion was reached was because of the finding that a self-assessment return comes within section 114. And one would ask, as a matter of principle, there's no reason that, certainly that I can identify, why 114 would be restricted to documents issued by HMRC only. Bearing in mind that we are now dealing with a system of self-assessment.
Okay, here you're trying to apply, if that's right, you're trying to apply that here to a claim for DTR or a claim under paragraph 51.
Yeah, it would.
Neither of which operate in the same way as a self-assessment return. So neither a Para 51 claim or a DTR claim made outside a return would have an immediate effect without the revenue taking some action. So I think you need to go further than McGuinness.
Well, but it's only, well, but I'm,
If McGuinness
well,
is right.
I was dealing with McGuinness for the principle about taxpayer documents. McGuinness lets me open the door to say some taxpayer documents
Yes, but
work.
the reason
And it-
the judge in McGuinness reached the conclusion she did, I think, is because a self-assessment return obviously takes effect as a self-assessment. It has a real operative effect in the tax system immediately. That's how it works, whereas these claims are different. The revenue would have to consider them and react to them.
Well, but in my respectful submission, if one looks at how 113 sub 3 is framed, we're just looking at documents required to be used in assessing, charging, collecting and levying. There isn't any reason for reading out particular classes of documents in the way that my lady has just outlined. It's not to do with the immediate effect of the document. It's just what's the purpose of the document.
Yeah, but you wouldn't say a set of accounts was fell into that category, would you? So there must be some limitation.
But my lady, this is a document where a claim is being made, and then it's either going to be given effect or not given effect. And
As someone who, unlike my lord and my lady, is not a specialist in this field, I've bound to say I find it pretty surprising. There's a provision that dates from 1970. It has not been established whether it purely applies to HMRC documents or whether it extends to taxpayer documents. It seems kind of a fundamental question.
well,
That seems to be at large.
I'm not aware of anything better than what I've shown the court. Not.
Oh, well.
I mean, I share my lord's puzzlement about that. I was about to make the same point, in fact. It is mysterious. It's a provision which has been there for a very long time, but in practice doesn't seem to crop up all often.
Well, but that, I suppose I go back to the point I made yesterday about the rather unusual nature of it. What is happening here is that because of the retroactive interpretation, what was done at the time is now being said that was wrong. Either there was a defect in the letter because it did the wrong thing, or there's an omission because it should have said give us credits and it didn't.
Well, can I suggest a possible explanation and see what your reaction to it is? The rubric to the section is 1 to 4 more errors not to invalidate assessments, etc. And if you just pause there, you might think, perhaps, well, this is just about HMRC documents not being invalidated by errors. And I appreciate you saying, well, if you look at the wording, it actually is capable of extending further. But might that be an explanation?
No, and I make 2 points. But, of course, this wording goes back to at least 1970. I can't recall now whether it's in one of the earlier iterations of the statutory regime, but it now has to accommodate self-assessment, point 1, and the heading, which is only at best an uncertain guide, and that does use the word etc. It's clearly not limited to assessments, so one can't assume that assessments are just things that HMRC does.
No, but the extension to self-assessments is easy to understand because effectively that's part of the big shift in emphasis.
Yes.
Put the onus on the taxpayer to do what previously the inspector
Lord,
would.
yes, and what we're looking at here is can it also apply to claims? And there's no reason in my submission why it can't also apply to claims in circumstances where we're dealing with provisions that say, well, this either goes in the return. If it can go in the return, it must go in the return. But if it can't go in the return, you can put it in outside the return. There's no principled reason for looking at the provision in such a sort of segmented way in my submission. And no reason why it shouldn't apply in an even-handed way, as between taxpayer on the one hand and
Can I
revenue
be
on the
clear
other.
as to how you say the section should properly be interpreted? Because I think if I've understood you correctly, the effect of your submissions is that this section applies to all taxpayer documents.
That are used in assessing, collecting, levying, etc. tax. Yeah.
Yeah.
Yeah. And you'd have to show that what was done is in substance and effect in conformity with, according to the intent and meaning of the Tax Acts. And you'd have to show that the mistake wasn't gross or fundamental, or the omission not gross or fundamental, I accept that, and that the document wouldn't have misled the inspector. And what I'm saying is that in this case, what was done was equivalent in nature. That's why I emphasise that.
Can you help us understand what the meaning and effect of the last part of subsection 1 is? I mean, it's easy to understand a requirement that substance and effect is conformity according to the intent and meaning of the Taxes Acts. That's maybe difficult to apply in practice, but the concept is easy to understand. But I'm struggling a bit more with, and if the property or person charged or intended to be charged or affected thereby is designated therein according to common intent and understanding. What on earth does that mean?
I mean, the easiest scenario is some form of assessment by the revenue. I accept that. That's the sort of paradigm for this. But in this case, the property could just be the dividend receipts, and they were identified by Standard Life in the schedules. Property affected thereby. They've said we've had these dividends. We've got our EU law right. We think you've overcharged us. Please pay us back. So
but I mean, just by way of illustration of my puzzlement, I mean, are you saying that according to common intent and understanding, a claim for an exemption is the same as a claim for credit?
I'm saying in this context, in the light of what we know from the European authorities, it's equivalent, and so it's sufficiently close. I'm saying I'm not...
How does that fit with the language of section 114? It says according to common intent and understanding.
I'm terribly sorry, no, I'm not sure I follow the question.
Well, the question arises out of by not following what the section's saying.
No, but
if we're looking at common intent and understanding.
Yes. But my lord, can I just go back half a step? As I understand it, and I may not be reading the section correctly, but my submission is that common intent and understanding qualifies the person or property charged or intended to be charged or affected thereby.
Yes, so you
as a matter
say
of language.
You say it doesn't cover the detailed tax
That's right.
analysis. So as long as you've identified the person and the property.
Yes. And the person's Standard Life and the property is the receipt of the dividend.
Yes, yes, I understand.
Yes. Perhaps I can, I mean, the general point I make, there were two cases cited below, but I'm conscious of the time, and neither of the cases is binding or gives any particular insight into principles. I simply say, given that exemption and credit are equivalent, and given that you can see from the revenue's response, which I showed the court yesterday, they were not misled in the sense that they knew that Standard Life were asserting their EU law rights. I might say square brackets, whatever those might turn out to be, given the uncertainty that existed at that time. One cannot say either that the mistake, defect, or omission, either that it was gross or fundamental, or that an officer would have been misled. So that's why I say if I'm wrong about simply how you characterise the claim document, 114 will actually come to the rescue. And then I think I've dealt with my submission 4, which is that if all of that's wrong, then one has to deal with the supervening principles of EU law. And I think I've explained how I say that that works in this case. I was just going to say the briefest of words, given the time, about issue 3, which is my own friend's appeal point. I won on this in the Upper Tribunal. This was Upper Tribunal 139 to 157. what we're dealing with here is that there were claims made in returns for relief for withholding tax, and there were inquiries opened by the revenue. Those inquiries remained open, and so the issue, when we come to issue 3, is when HMRC closes the inquiry, does it have to do so on what we would say is a correct view of the law when it's closing the inquiry? And we may need to look with Malone and Friend at Schroeder Institutional Growth. That's the lead case on this. I make 2 points in particular on this. The first is looking at section 790. Credit for tax paid, credit for withholding tax, credit at the FNR, they're all forms of unilateral relief. One gets that out of section 790 sub 3.
The claims of withholding tax
Yes.
relief on the facts of this case
Yes.
were not unilateral.
That's right, and I'm going to make a second point to deal with that.
Okay, so your point is that in principle you can
Exactly.
claim.
I'm doing this in stages, my
Okay.
lady. So that's stage 1 is 790. And stage 2, and this is important because this responds directly to my lady's question, is that under the UK provisions, a taxpayer does not make distinct claims for different types of double taxation relief credit. And that's true as between treaties and unilateral relief, just as much as between different kinds of unilateral relief.
When you say you do not make distinct claims, does that mean when you look at the legislation?
Yes,
you
the provisions only contemplate. If you look at section 788 sub 6 and section 806 sub 1, which are the only provisions we've got to go on, they do not contemplate a distinction between treaty claims and other kinds of credit relief. There is a distinction between relief under Chapter 2 and other kinds of relief, but relief under Chapter 2 is credit. That's 788 sub 6.
When you say, yes, but they do require a claim to a credit.
They do, and my simple point under issue 3 is there was one, and the tax position in relation to that claim has remained open. Milano Friend has got various criticisms to make of that, but if I may, I was going to deal with the criticisms in reply once he's actually made his submissions rather than trying to preempt everything. But they were the 2 headline points I wanted to make on issue 3, just so the court sees where the battle lines are on that issue. Issue 4, which is Schedule 1 capital A, is just picking up the point we make in paragraph 42 of the appeal skeleton. I don't want to spend really any time on this because this is a sort of if all else fails argument, and it relies on 2 things. It relies on me being right about what EU law principles require, and on there being no other location in the domestic statutory provisions to give effect to those principles. So what I'm saying, for example, is if paragraph 51 claim is invalid, take the Standard Life letter, and if that letter can't take effect as a claim for double taxation relief, either as a matter of construction or pursuant to section 114, if I can't deal with the matter through paragraph 51 and some conforming interpretation or moulding of paragraph 51, one would have to look elsewhere. And looking elsewhere, Schedule 1 capital A provides a regime that governs claims.
Okay, so is this an aspect, as I understand it, the way you've just put it, it's really an aspect of conforming interpretation?
Yes.
Using these EU principles on which you rely to read Schedule 1A in a particular way.
Yes. So if I need to find some other location that's not either Para 51 or Section 806 sub 1 to validate these claims, Schedule 1A is a place that one can look. And I just note that paragraph 4 sub 1 in Schedule 1A contemplates the possibility of repayment of tax. That's authorities 21. So it's at least consistent with the outcome that these claims sought. So that's all I really need on issue 4. issue 5 is in large measure a replay of the debate on issue 2, but by reference to the fidelity document.
When you
rather
say
than
it's a
standard life.
replay of issue 2, as I understand it, it's not a replay of the arguments about paragraph 51. It's a replay of the DTR. It has to be read as a DTR.
It is also a replay of para 51, I'm afraid, in that the First-tier Tribunal held that the claim could take effect under paragraph 51, because it did still request repayment. So one first of all has to ask what is this claim doing, and I accept, of course, that it talked about amending the filing position. We saw that yesterday, and that the letter was written outside the 1 year period for amending the return. So just looking at the domestic provisions, it can't have amended the return. But what it did do was indicate that what was wanted was a tax repayment.
Can you remind us where that?
Yes, I'm afraid it's in the first tier's decision at paragraph 146. Because
it took us to the actual claim.
I think we. I'm not sure if we've actually handed up the original. It was meant to be coming. I'm sorry if it hasn't.
Which paragraph? Yes, decision.
It's paragraph 146. Core page 313 sets the letter out. Is that just the covering letter?
It's got the whole thing. It's got
Okay, which is already in the second.
Yeah.
Yeah.
I'm very grateful to Ms. Belgrano, who has the original of the letter, if you'd like to see it in that form. It doesn't say anything different to what's set out in 146. This was the point. The clip I've just been handed has got, and it looks like what's been done here, I think I'm going to be right in saying, is that this must have come from the Upper Tribunal bundles, judging by the page numbering. So there's no difficulty with producing it. The computations are what was included in the supplementary bundle, but for reasons that I'm afraid I'm not able to assist with, the covering letter wasn't. So page 104 of the supplementary bundle is the same as what's marked here, bundle page 2794. And nothing turns on the computations. Just looking at the letter itself, I fully accept, we covered this yesterday, they say they want to amend the tax filing position. They refer to paragraph 31 of Schedule 18, which is dealing with amendments. But they explain what their original tax computations and returns did. They explain what their proposed amendment is, and they do make clear that what they want in the third paragraph is a tax repayment. And that's why the first tier found, and I support this as an alternative analysis, this is their 151 at the bottom of 314, that the EY letter satisfies the necessary requirements for a claim under para 51. But the stages here, it's a similar group of 4 points to the issues under issue 2, that what Fidelity has done is equivalent to a claim for, one might call it full DTR, in the sense of sufficient DTR to eliminate the tax liability. And it's essentially the same points that arise under issue 2. That if that's wrong, para 51 is a provision under which this letter is capable of operating, because they would have made a mistake if they're right in what they say in the letter. And as I said, under issue 2, paragraph 51 is a valid route. Thirdly, if that's wrong, section 114 Taxes Management Act.
So these are exactly the same arguments as under issue 2.
But of course by reference to the terms of this document rather than the Standard Life document. And fourthly, the effect of the supervening EU principles. I don't think, I'll see how my friend develops his case, but certainly below, the issues 2 and 5 have been argued out in a very similar fashion, and at this stage I'm content to leave it in that way in this court. Please may I deal next with issue 9. This was dealt with sort of on its own by the FTT and by the SHM, but actually it's closely related really to what the first tier described as the other category A issues, because this is also an instance in which it's Henderson was the relevant fund. It was seeking to assert its EU law rights prior to the conforming interpretation being established. And this is developing the points we make in the appeal skeleton of paragraphs 43 to 46. This was dealt with by the Upper Tribunal in paragraphs 231 to 245 of its decision, which starts at core bundle page 190. And as we'll see, this raises a discrete issue about the statutory provisions on the effect of an amendment to the return after an inquiry has been opened. So what we're dealing with is an in-time amendment, but after inquiry open. And it also will bring back in issues relating to para 51. Can I just take this in stages? I'm very happy to show you that we've got the documents in the supplementary bundle, but I'm hoping I can do this just by reference to what the Upper Tribunal says and do it in a more conceptual way. Upper Tribunal 232. What Henderson had done in its return as filed was treat EU source dividends as exempt and treat non-EU dividends as taxable with credit for withholding tax. And we're looking here at the return for the accounting period ending October 2007. And an inquiry was opened into that return within the time allowed, 25th of July 2008. That's the end of 232. Henderson sought to amend the return 28th September 2009. And what that amendment sought to do was to exempt the non-EU dividend income as well. So that amendment was made within 12 months of the filing date, so it's within the time for an amendment, as we'll see when we look at paragraph 15. But what had happened is that before the amendment was made, the inquiry had been opened on 25th of July 2008. And I probably do need to show you one document, I'm sorry, which is the covering letter for the amendments in the supplementary bundle. And it's supplementary bundle, page 151, letter dated 28th September 2009. And it's the explanation for what's going on under the heading year ended 31 October 07.
So which tab is that, please?
Page 151 should be behind tab 29.
Thank you. And it's put very shortly that you can see this. So here's our amended tax computation amended to treat overseas dividend income as non-taxable, which is in accordance with the legal precedents that the UK tax law under which the dividends have previously been treated as taxable is unlawful.
I notice in relation to other periods that the next paragraph does make a para 51 claim.
Yes, because it would have been too late by then to amend the return. I may be in danger of being about to get this wrong, but I've no doubt that 03 to 06, well, it doesn't matter. What I'm about to say doesn't matter. I can check and I'll come back to it if it matters as to the status of those years. We're not worried about Henderson 03 to 06 at the moment for the purposes of the cases that have been treated as significant for this appeal. There may be issues about those years that would be affected by the rulings on other issues. And then just to complete the picture, the revenues response, that's 9th of October 2009, that's behind tab 32. So I was just going to skip over the detail of what the amendments to the returns were in 30 and 31. And it's the second sentence, so an inquiry's already been opened. So the first sentence is opening the inquiry into 08, which we're not concerned with, but then there's acknowledgement of receipt of the amendments for, among other things, 07. These will be kept until the inquiries already open are concluded. And you can see one of the things that the inquiry is going to cover, and that's in the second paragraph. There are subsequent claims made by Henderson, which are in the supplementary bundle, but they're not relevant to issue 9. What the closure notice did, and this is recorded in the first tier's decision in paragraph 90, sub 92 to 94, is that it brought into charge the EU dividends which had been treated as exempt, and it allowed Henderson's claim for withholding tax. And that closure notice, as it happens, is in the core bundle at page 393, but I don't think we need to look at it. I'm content with the first tier's summary.
Sorry, which paragraph was the FTT?
It was 90, which sets out the statement of agreed facts, and it's subparagraphs 92 to 94.
It's on page 299.
I'm very grateful. And if I can just summarise where we get to, because the significance of this issue is what adjustment has there been to tax payable? Because the revenue accepts that for the EU dividend income, which was originally returned as exempt, the closure notice adjusts the tax payable for the EU dividend income. So Henderson is able, says the revenue, to make a claim under section 806 sub 2 following the closure notice for double taxation relief calculated by reference to the nominal rate. But what the revenue says in relation to the non-EU income, which was originally returned as taxable, they say there's been no adjustment to tax payable, and so there's no ability to make that claim under section 806(2). So the statutory question, I suppose, we're interested in is how does 806(2) interact with paragraphs 15 and 31, and has there been any adjustment to the amount of tax payable for the purposes of section 806 sub 2? Because the Upper Tribunal's conclusion, going back to the core bundle, this is paragraph 244. The conclusion is, towards the bottom of the core 192, that the amendment didn't give rise to any adjustment to the amount of tax payable for the purposes of 806 sub 2. And my submission is that conclusion is wrong in law, because it misunderstands the statutory schemes set out in paragraph, particularly paragraph 15 and 31 of Schedule 18. Could I show the court, please, those provisions? Paragraph 15 is in Authorities Volume 1, tab 10, page 130. And it's 15 sub 1 that gives the company the ability, and it's permissive, it says may, to amend its return, and 15.4 is the deadline of 12 months after the filing date, and that deadline was complied with here. The version of paragraph 31 that was in force at the time of the closure notice is the version that's set out actually in the Upper Tribunal's decision, and can I make my apologies because it's an earlier version that's been included in the authorities bundle. Yes. And I think I'm remembering correctly that in the Upper Tribunal, where Milano Friend and I got to, was that looking at paragraph 31, it was right to look at it as it stood at the time when the closure notice was issued, rather than the earlier stage of when the return was sought to be amended. Exactly. Exactly. What one needs is what the Upper Tribunal sets out in paragraph 234 for paragraph 31. It's 31 sub 1. Is the situation we're in here. So the return's been amended, but at a time when the inquiry is in progress and it is in relation to any matter to which the amendment relates. Sub 2 amendment doesn't restrict the scope of the inquiry, but may be taken into account in the inquiry. And then 31 sub 3, this is looking at the effect of the amendment on the amounts in the self-assessment. And this is in principle engaged here because Henderson is saying these dividends should be treated as non-taxable. So the amendment in the tailpiece of sub 3, it doesn't take effect while the inquiry is in progress. But then subsection 4, that tells us how, the way it's put is how an amendment whose effect is deferred under subparagraph 3 takes effect. And the provision that we're in is little b, because we're not within little a, because the conclusions in the closure notice, they didn't say that the amendment wasn't taken into account, or that no amendment of the return was required, because that would have meant that the amendment did take effect, and that would have meant that Henderson had a return actually exempting not just the exemption of the non-EU income would have applied, but that isn't what happened. So we're within B, any other case, and we're told there that the amendment takes effect as part of the amendments made by the closure notice. So looking at these provisions together and reading them as a whole, as in my submission, one needs to look at 15 and 31 together. We know that there's an entitlement to amend the return within the 12 months. That's 15 sub 1 and 15 sub 4 sub A. We know that when there's an inquiry, the effect of the amendment is deferred, because that's the way it's put at the start of sub 4. But the amendment is nonetheless to take effect. That's 31 sub 4 sub B. And looking at that legislative context, what one sees is that paragraph 31 really is about the timing of when it is that the amendment is to take effect. It shouldn't be being read as taking away or undermining what is a right to amend granted in paragraph 15 sub 1. But the effect of the Upper Tribunal's analysis is that the amendment is being, in my submission, deprived of any effect whatsoever. Because what the Upper Tribunal is saying is that the amendment had no impact on the amount of tax payable. And I say that that can't be a correct interpretation or application of paragraph 31 sub 4 read with paragraph 15. Because the amendment is to take effect. So where that gets onto is that, going back to what Henderson was doing, all of the dividends, and here relevantly the non-EU dividends, they were amended onto an exemption basis. And what of course then happens is the closure notice conclusions, they are inconsistent with that amendment, and so it must follow in my submission that what the closure notice does in terms of section 806 sub 2 is increase the amount of UK tax that is payable. So there is an adjustment to the amount of UK tax payable.
This is the Upper Tribunal use the term scintilla temporis. You say you've got to treat the amendment as taking effect and then essentially immediately countermanded by the closure notice.
That's right.
I mean, I do say I can see that if you're wrong on this, there is a real slightly odd distinction between an in-time amendment made when no inquiry is on foot, where under issue 1, as I understand it, HMRC accept that relief is available, Whereas under this issue, if the inquiry happens to have been opened 2 days earlier and the letter is, or maybe not even arrived, but the inquiry is open, the position is radically different.
Indeed.
Which at least calls for
Well, it calls for
careful
close
consideration.
examination of whether that can be a correct application interpretation of para 31 sub 4. Exactly right, my lady. And particularly in circumstances where we know, and that's why I showed you the covering letter of 28 September 09, that the reason why the amendment's being made is to seek to give effect to EU law rights. So that's the main way in which issue 9 plays out, is as a point of statutory interpretation as to how paras 15 and 31 in Schedule 18 link together and how they link with section 806 sub 2. Just for completeness, if I'm wrong about how those provisions work, there is still the point that's raised in paragraph 46 in the skeleton, which is that the letter and amended computations, they are still capable of operating as a valid paragraph 51 claim. That was what the first tier said. So the first tier was also against me on issue 9, but it didn't matter for Henderson because they said at paragraph 185 that those documents still operated as a para 51 claim.
That was FTT 185.
FTT 185, yes, that was the FTT's ultimate conclusion.
There's nothing that restricts para 51 claims to saying these have to be made when you can't do this by amendment to the return.
I don't believe so, Milady.
Okay. Unlike some things
Unlike
about
some other
claims
claims.
where you have to do them in the return.
Yes. And then the other point that's made in 46, and again, this is replaying really issues 2 and issue 5. One would have to ask if it doesn't work as a para 51 claim, can the amendment nonetheless work as a claim for full double taxation relief? That was what I was proposing to say about issue 9. I was going to deal next with issue 10, so this is sticking with the order in the skeleton and introducing at this point FII Supreme Court 3. Issue 10 was dealt with by the Upper Tribunal at paragraphs 246 to 258 in its decision, which started core page 192. Core page 192. And this issue, as we'll see, it takes us, if you like, I suppose, a bit more into the complexity that ends up being caused because there are multiple years, and because, of course, the receipt of dividend income is not the only thing that's going on for these companies. So, in particular, there are, and investment funds in particular. So there are especially management expenses that are being set off under the automatic application of the UK provisions. And issue 10, the lead appeal was fidelity. And if I can start just by setting out what was going on in a fairly generic way, and then can I also just show the tribunal actually what the formulation of issue 10 before the First-tier Tribunal was, because where the Upper Tribunal ultimately has gone wrong in my submission is actually in misunderstanding what issue 10 was about and introducing an additional requirement that didn't actually really form part of issue 10. That's part of where the problem in my submission arises. And the reason I'm making this slightly long-winded introduction is that by the time of the First-tier Tribunal hearing, which I think was June 2021, we had had the hearing in FII Supreme Court 3 in December 2020, but not yet the judgment. And the Supreme Court in FII Supreme Court 3, one of the issues they were going to deal with in FII was an appeal actually from this court's judgment in 2010 about how one dealt with the interaction of management expenses and the EU law arguments. They were going to do that in the context of the restitution claims, but it was thought the Supreme Court judgment should actually either answer or get us a long way towards answering issue 10, and that's one of the reasons, as Judge Brooks records, why his decision was delayed. So he waited for the judgment in Supreme Court 3 and then gave the opportunity for submissions. So just what was going on, first of all, one can see this in 247. So we're dealing actually with 4 accounting periods, 07, 08, 09, and 10. And there are what's called surplus management expenses in 07. So the management expenses actually exceeded the tax liability in 07. So they carried forward into later years. And then in those later years, there were also some more management expenses as well. What, of course, that means, because management expenses were applied automatically under the UK provisions as originally enacted, and I'll show you the Supreme Court's explanation of all of this. What that meant is that even leaving to one side all the issues about nominal rate credit or credit for tax paid, you'd have a situation where double taxation relief is being not used, and there was no provision for the double taxation relief to be carried forward in the UK provisions as originally enacted. So if you've got management expenses in, let's call it year 1, so 2007 in this instance, those management expenses, they get applied in priority to any double taxation relief, and then again, under the provisions construed without regard to EU law, there's no provision for double taxation relief to be carried forward. And so in a subsequent year, if there is taxable income in that subsequent year, you've no longer got the DTR, and so you'd have a tax charge. So it's a situation where in year 1 you might not have a tax charge because there are management expenses that are applied, but then year 2 the DTR hasn't carried forward, and so if there's income there would be a tax charge, and that tax charge would not have arisen if the original dividend income had been exempt. Now the way that issue 2 was actually formulated is probably easiest. I'm so sorry, yes, issue 2. Yes, I'm sorry, I said issue 2, I meant issue 10. I'm sorry, milady. The way issue 10 was formulated is actually easiest to see. It's a document that our side prepared, but it correctly records issue 10 as it was set out in the list of issues. And it's where the appellants set out their proposed answers in the First-tier Tribunal, and that starts in the supplementary bundle, tab 42, page 205. And I'm not going to worry about what the appellant's answers were or its submissions on the outcome, because that was at issue. But page 212, right at the top, has, that was the agreed formulation of issue 10. And I suppose what that's doing is anticipating what it's thought might be relevant in the light of the likely answer from the Supreme Court in FI Supreme Court 3. So that was actually how the issue starts off.
Fully answered.
I was going to indeed, and that's why my submission is, if you're looking at issue 10, where the Upper Tribunal's gone wrong is in imposing an additional requirement that there must be a claim for the double taxation relief, and I'll explain that. Because, as my Lady Justice Falk rightly says, the way issue 10 is put, it is essentially fully answered by the Supreme Court, because the answer is that it's the failure of the UK provisions to allow the carry forward of double taxation relief that breaches EU law.
You're not saying that the UT were not entitled to take the point if it was corrected?
No, I'm not saying that. I'm just saying.
You're not making a procedural claim.
No, I'm not. I'm saying they've gone wrong when you look at the Supreme Court's judgment in reading in this additional requirement to claim double taxation relief in my example in year one.
Well, I'm a little puzzled then, because that's an argument that is simply wrong in law, in which case, why are you placing so much emphasis on how the issue was originally formulated? I mean, if you had a procedural objection, this is simply unfair, taken by surprise, all of that kind of stuff, then it would be highly pertinent to look at how the issue was originally formulated. But if it's a pure question of, well, they're wrong in law, then how the issue was originally formulated is irrelevant, isn't it?
I can see your lordship's not going to get very much help out of the formulation of issue 10 in dealing with my submission on whether the Upper Tribunal's misread FI Supreme Court 3. I can see that. It simply struck me that in a case that is complicated like this, it was relevant to see what it was the issue was, and then to situate it, because I'm about to show you what the Supreme Court actually decided. I'm not saying that the formulation of issue 10 means I win, and I'm sorry if your lordship takes the view that that wasn't a useful use of time, then I'm sorry.
All right.
The ruling that the Upper Tribunal makes.
Well, don't we need to look at the Supreme Court next? Because you've just told us that the Upper Tribunal misinterpreted or wrongly interpreted the Supreme Court. So doesn't it help to look at what the Supreme Court said?
Well, it doesn't, but I was just going to show your lordship what the Upper Tribunal actually said in terms of its ruling, because I've summarised it. I just wanted to be fair and say that appears particularly in the first sentence of paragraph 256 on page 194. That was the submission that was accepted and which I'm challenging as a misreading of what the Supreme Court said.
Just so I understand how factually this fits in with the other issues, the test or lead appellant on this issue.
Yeah.
Are we in a situation where there's nothing you can point to that would amount to a claim?
Yes, we're not saying that we made a claim in year one for DTR. What we're saying is that we rightly made our claim in respect of year two,
Okay.
and we did that within the applicable time limit. So, FII Supreme Court 3. is Authorities tab 48, which should be within volume 4. And the section of the court's judgment that starts at paragraph 119, which is on page 1351. And this, of course, is in the context of the restitution claims that were being brought. And I tried to summarize what was happening under the UK system as originally enacted, and that's set out by the Supreme Court in paragraph 121. And you can see the basis of the argument that was being put on behalf of the claimants then at the end of paragraph 121. And then 122 explains that what by this stage has happened is the FNR credit's been established, but then 123 is the explanation of this, if we might say, further problem caused by the automatic application. I'll just focus on the management expenses for the purposes of these submissions. Group relief was at issue in FI as well, but that doesn't arise here. And then there's a more detailed explanation of how the reliefs work. Management expenses at 125, it was section 75 of it, and that was an automatic application. That's paragraph 125 in the court's judgment. And then the explanation of the double taxation relief positions in 128, 129. And then the problem is summarised in 130. So it's because the DTR only comes in against tax otherwise payable, so it's coming in after taxable profits have been determined. So DTR gets applied after other reliefs, including management expenses, had already been taken into account. That's why DTR credits might not be fully used in a given year, and indeed in this case wouldn't have been fully used in year one in my example. And then 131 summarises the problem under EU law, and perhaps I could just ask the court to read 131. And then 132, this isn't particularly relevant to issue 10, but it is relevant to issue 8 and some of the later issues. So if I can just ask the court just to note it at this stage. The eligible unrelieved foreign tax rules, they come in for dividends arising after 30 March 2001. But what you can see in 132, and the court comes back to this, is that the youth rules, they don't fully ameliorate the problem that's been described, because the credit continues to be based on foreign tax paid, and it can only be set against particular categories of dividend income. what had happened by the time FI Supreme Court 3 was decided is that the Court of Justice had decided a case called Salonen, and the Supreme Court goes through that in some detail in recording claimants' arguments, paragraphs 134 to 139. But given that the Court has now told us what the analysis of Salonen is, I'm just going to pass to 140. And that's what the Supreme Court draws from Salonen. Could I just ask the Court, please, to read that? So having identified the problem with the UK provisions, 141, it's then the question of the appropriate remedy. And 141 sets out the competing submissions. So the claimants were saying if there's tax in a subsequent tax year, so that's year 2 in the simple example I was giving, then you get that tax back on a San Giorgio basis. But if you've not yet paid tax, the unused credits remain available for use. And then the revenue between C and D, they were suggesting a different approach, which was to give a conforming interpretation relevantly here to section 75, so you'd carry forward the management expenses. 142 is the Supreme Court's rejection of the revenues approach. And that was closely based on identifying where it was that the problem lay. So the problem wasn't with the rules governing management expenses. We see by letter E, the Court tells us the provisions on management expenses, they're fully compliant with EU law. The problem by letter F was that legislation which prevents carrying forward of unused DTR credits, that's precluded by EU law, because it results in a difference in treatment, which is then explained. It's indirectly subjecting the dividends to economic double taxation. That's the year 2 tax charge that you wouldn't otherwise have had. And so the Court says if the problem can be resolved by addressing the DTR legislation, that's the appropriate place to find the solution.
I notice in 143 the Supreme Court says that impact is a qualification on the obligation to interpret national law in conformity with the requirements of EU law.
My Lord, yes, and that's consistent with the submission I was making about it yesterday. So the conforming interpretation, which to be more accurate with the solution, is set out in 144 and 145. So there's a problem that you only get DTR credit in respect of particular income against tax computed by reference to the same income. So that rule's contrary to EU law to the extent it's preventing unused DTR credits from being carried forward. And then they say that in the remainder of 144, there's a requirement arising under EU law that it must be possible to carry forward unused DTR credits. And that was at all material times directly applicable as law in the UK. That had to be given effect and priority to inconsistent domestic law, whether legislative or judicial in origin. That's what then frames in 145 the solution that's set out by the Court. So they're disapplying that rule that you only get credit in respect of particular income against tax computed by reference to the same income. That's to the extent it stops the necessary carry forward. And instead one has to give effect to what's called the EU rule that unused DTR credits calculated on an FNR basis can be carried forward for use against tax liabilities arising in subsequent years. And that's put in terms this time of disapplication. And then the effect of that is explained between letters E and F at the end of paragraph 145. So for the future, unused credits, they must in principle be regarded as remaining available. That's notwithstanding any statutory provision or other domestic rules of law to contrary effect. And then 146 deals with the situation where tax has already been paid as a result of the inability under domestic law to carry forward unused DTR. And there's reference then to the requirement of effective legal protection, and that has an impact here because it's said, well, it's not enough to say you've still got the credits. And the reason for that is that the state has received a payment of unlawfully levied tax at some point in the past. That's within the San Giorgio principle. So that requires under EU law restitution of the tax and an award of interest. And 147 picks up the revenue submission that the only remedy lay in damages. That had actually been the position that had been established in FI High Court 1 and FI Court of Appeal 1. And that's set out up to 153. The Supreme Court overturns what had been said below in 154. So they're concerned with payment of tax, not its non-payment, and payments were the result of the inability to carry forward unused DTR credits, and that's the direct consequence of the failure of the UK regime to comply with EU law. And saying it's within the ambit of FI CJU2 para 84, that's a way of saying it's within the San Giorgio principle. And that's what one sees at paragraph 155. So San Giorgio claim lies for the recovery of tax which was paid as a result of the impossibility of carrying forward unused DTR credits. And they explain why the levying of tax was unlawful. And 156, those San Giorgio claims, they're being classified as claims for restitution. And that, of course, is the set of claims that's before the Supreme Court in that case. So you can plead a Woolwich claim or you can plead a mistake of law. And one of the ways in which the revenue tried to meet that point was to say the tax was lawfully due. And perhaps just need to explain what that submission was getting at. That was looking at year 2 in my example and saying the payment of tax in year 2 wasn't any breach of EU law. And the answer to that is given in 157 that that's not right because there is a breach of EU law because the year 2 tax charge involves indirect double taxation of the foreign source dividends, which is unlawful. And then the other point the revenue made by Levis C was to say that the proposed solution that was contrary to the UK system, which didn't recognise carrying forward a DTR, that wasn't an answer because that aspect of the system was unlawful, so it had to be disapplied.
Yes, I at least struggle a little bit with I can see the disapplication of the prohibition, but you then have to effectively pretend that some machinery is in the tax system that does allow carry forward, and we haven't really we're not provided
We're not
with
given a-
obvious tools,
We're not given a great deal of guidance on that, that's true.
and that's at the heart of this issue.
It is, and that's what this court needs to grapple with. But just before I get to that, should just deal with 158, which is the last bit of guidance, and that recapitulates really and summarises the conclusions. And the focus is on tax being paid as a result of the inability to carry forward unused credits. And it said a claim lies in restitution. Well, that's obviously right in the context. That's the kind of claim that the Supreme Court is dealing with. What we're dealing with here, of course, is statutory claims. And then it's explained, essentially, you can't have double counting. So if you claim repayment, you can't at the same time say, I've still got the credits.
So can you help me on this? This seems to clearly establish that the appellants involved in SU 10 would have a straightforward claim for restitution.
Yes. But
Why does it follow that they've got a statutory claim?
because there's no difference in principle between the statutory claim and the restitution claim, because the statutory claim is still making the same complaint.
I don't understand that because there is a San Giorgio claim available. That's what the Supreme Court have told us.
Yes.
And it's a restitutionary claim.
Well, they don't say that that's the only claim. It doesn't follow from the Supreme Court's analysis that the only way of responding to the breach of EU law is through the High Court claim. The Supreme Court was dealing with the claims that were before it.
Yeah, I appreciate they don't say in terms, and you can't do it by a statutory claim, because that issue wasn't before them. But the question is one of remedy for the breach of EU law.
Yes.
And they reject the argument that the remedy is a Frankovich claim for damages. And they say, no. The remedy is a San Giorgio claim for restitution.
Yes. And
so given that there is a remedy by way of a San Giorgio claim for restitution, why is that not compliant with the UK's obligations?
Muller, what we're asking at this is, so that the point in fidelity, in my year 1, year 2 example, and I don't understand there to be any dispute about this, what Fidelity have done is made a claim for the recovery of unlawful tax in year 2. Of course, that's a statutory claim. We're not concerned at the moment with any High Court claim that they might have made. Fidelity, I think, is one of the claimants that was in Class A, but we're not concerned with any High Court claim they might have made. But what we're dealing with is a statutory claim in respect of year 2 enough? That's the burden of issue 10. What the Upper Tribunal says is you don't get to make a claim to recover the unlawful tax in year 2 unless you made a credit claim in respect of year 1. That was UT 256.
You can see if you read, SC3 clearly doesn't address this point because they look in economy restitution.
Yeah.
The Supreme Court referred to unused credits must be able to be carried forward.
Yes.
One argument in favour of the UT's approach is, well, they're only unused if they've been claimed in the first place, which is what the domestic tax system requires. So you need to face the argument that as you accept, DTR requires a claim.
Yep.
You've got to explain, I think, why SC3 is the authority not only for the things it's obviously authority for,
yep,
but also is sufficient authority to say, well, you only need to make that claim in year 2.
Yep.
Bearing in mind, none of this is written down in a statute.
Indeed. And the starting point for all of this, and this I say we do get out of SC3, is that the illegality only arises in year 2. We know that from SC3. In particular, from the discussion at paragraph 142, that there was nothing wrong with the rules on management expenses.
Well,
And
I would potentially take issue even with that, because if you think about how it works, you've got to have the DTR arising in year 1 as a credit to be able to be carried forward. Yet under the domestic tax system, it simply isn't there because management expenses have displaced it.
My lady, my submission is that true it is that in a High Court restitution claim, the complaint is, I have overpaid tax because you did not give me the credits to which I was entitled. That's how you would formulate a Woolwich claim. My submission is that that complaint can equally be ventilated in a statutory claim. And this perhaps takes me back a little bit to some of the issues we were discussing in relation to paragraph 51. A lot of this comes back to how one characterises the mistake in para 51 terms. There's no difficulty in my submission in saying if you're looking at a statutory claim, looked at in the context of these provisions, which are not prima facie complying with EU law, or no, needing to be conformingly interpreted, and we see there's disapplication going on here as well. There's no reason why in a statutory claim a taxpayer cannot say, in year 2, I've overpaid tax because I didn't have sufficient credits available.
Sorry, I maybe have missed the point here. I thought this wasn't a paragraph 51 claim.
Well, if one the letter that Fidelity sent is actually the same letter that we're talking about under issue 5.
Sorry, Mr. Brumner, it's already complicated enough.
Well,
I didn't understand, I hadn't understood this issue, and I don't think my lord did either, as having sort of an alternative of paragraph 51 in year 2. I thought this issue as it now arises post SC3 is simply whether it's sufficient to need a claim to do a claim in year 2,
yes.
or whether you have to claim in year 1.
Yes, and what I'm saying, as a matter of fact, the claim that Fidelity made that is relevant to this issue is that same 25th of February 2013 letter that we've been looking at under issue 5.
That was handed up.
In which case this wouldn't be a distinct issue from issue 5.
I'm really confused.
Well, it's an additional issue to issue 5 in the sense that if the Upper Tribunal's right, there's no unlawfulness in the first place.
Well, it may be that Mr. Hewitt has to help us with this and it stands out, but it is quite helpful to us to have some idea of how these issues
Oh no, I understand that, my lady. Yes.
And I thought I did, rather more than I now do.
Well, I'm sorry if I've set a hair running, but I mean, having looked through the Fidelity claim documentation.
Well, at the moment, you seem to be saying, and maybe I'm misunderstanding you, that you have a straightforward answer to this, which is your answer to issue 5.
Yeah.
But in that case, it's not a separate issue.
Okay. Let's see.
This may be a point about the particular test claimant,
Potentially.
rather than anything else.
But maybe it goes back to what you were saying a moment ago, which is that the issue is characterised as being an additional point that you are advancing.
Yeah.
In other words, assume you fail on issue 5.
Yes.
are you saying you can still succeed?
Well, I need a claim of some kind within time. What I'm saying is that analytically that claim is a claim in respect of year 2. And you can't beat what Fidelity have done.
So,
by
so
saying
do
there's a
you
prior
accept that we
requirement
should
under year
approach
1?
that argument on the footing that it's not a paragraph 51 claim? Because if it is a paragraph 51 claim and you've succeeded on issue 5, you don't need this.
Let me just reflect on your lordship's question,
You understand there was a DTR claim
which isn't in the
for year
manual.
2. No, it's in paragraph 248 of the Upper Tribunal, I think.
Let's have a look.
But I don't know what that's from.
Oh, that, yes, 248. Thank you.
Yes,
Maybe year 2, not year 1.
But the point may still stand that if you win on issue 5, at
This
least
make-
in relation
at
to
least in relation to fidelity, it may
this
go
might
away.
fall away.
That is possible. May I reflect on that and perhaps come back to this once we've had a chance to look at the claim documents. My recollection, because my own friend helpfully points to paragraph 248 in the Upper Tribunal's decision and the alternative protective claim 31 March 2010. But I think that's only concerning the EU dividends.
I see.
The point of principle that 256 gives rise to, in that example I was giving of year 1 and year 2, is there very much, does there need to be prior claim for credit in year 1 in order to get into any argument about unlawfulness? Or when we're looking at the statutory claim, are we dealing directly with the unlawfulness that's been identified in year 2? And in that sense, we are needing to engage with the distinction that the Upper Tribunal seems to have thought applied between High Court restitutionary claims on the one hand and statutory claims. Because if one's looking at the width and scope of the San Giorgio principle, a statutory claim is just as much a claim in order to give effect to the San Giorgio run. That is what I was proposing to say about issue 10. It may be that I'll need to come back to exactly what it means for fidelity on the ground, but I hope that at least covers the point of principle. That takes me on to what we describe in the skeleton as the second key question. So moving on to ground 2, because I think I've done the issues that raise questions concerning steps taken before the conforming interpretation was established. And under ground 2, what I'm dealing with is the interaction of section 790 as conformingly construed with the rest of the UK double taxation relief code. And that's particularly relevant to issues 6 and 7 on section 806.2. And it's also relevant to the issues concerning double taxation relief and UFT, the eligible unrelieved foreign tax. So that's issues 8, and B and E are closely related. Also 11, and I suppose in a sense it might have impact on issue 10, because 10 and 11 themselves are very closely related. But can I please begin in dealing with issue 6, and here I'm developing paragraphs 55 262 in the skeleton. And what we're concerned with here is, in the light of the conforming interpretation, how one interprets and applies section 8062. And the Upper Tribunal, in my submission, it started in the right place, but then it went wrong. It started in the right place because in paragraph 193, which is in the core bundle at page 182, it accepted, and this in my submission was correct, and I'll show the correct Prudential Court of Appeal and what that decides. It accepted that once section 790 is given a conforming interpretation, then other DTR provisions will apply in accordance with their ordinary meaning. And my complaint, and this happened, as we'll see when we look at the issues, in a number of different ways, is that the Upper Tribunal in my submission failed to give effect to that principle. Because rather than permitting the foreign nominal rate credit that EU law required to take effect by reference to other provisions of the DTR code, it seems that what actually ends up happening is a credit is created which doesn't properly interact with other provisions in Part 18. Can I start, please, with section 806 sub 2? It's set out by the Upper Tribunal in paragraph 182, but in the original, it is Authorities Volume 1, tab 7, page 105. And 8062 is quite densely drafted. The draftsman's dealt with the ordinary 6-year time limit in subsection 1, and then I found it helpful, although I can see there might be different ways of slicing this up and distinguishing three broad questions when it came to 8062. Has there been an adjustment of the amount of any tax payable, either in the UK or under the laws of any other territory? Two, is it the case, this is dealing with the starting point of sub 2, that the amount of any credit given under the arrangements has been rendered excessive or insufficient by reason of that adjustment? And then third broad question, is the claim made no later than 6 years from the time of the final determination that's material in determining whether any, and if so, what credit falls to be given? And we've also got to look at whether the claim is one to which the adjustment gives rise. So what 806 sub 2 is doing, it's providing for an extended limitation period over and above the default 6-year time period specified in 806 sub 1. Just in terms of the context, under sub 1, even if an accounting period is otherwise closed, the taxpayer still had 6 years to claim DTR without needing to invoke 8062, 6 years from the end of that accounting period, 8061B Roman 1. And so what 806 sub 2 must be dealing with is unforeseen events which may produce effects more than 6 years after the end of the relevant accounting period. And it's a two-way street. It may operate to increase or to decrease the amount of double taxation relief that's due in the UK. So this is both about preventing a taxpayer obtaining an unfair advantage, but also about avoiding detriment. And some of that is to do with the fact that there is, one might say, some inherent unpredictability in credit being provided for tax in another jurisdiction, and then how that is recognised under UK rules. When it comes to issue 6, I'll just deal with the facts, and then that's probably a convenient, or I can stop now. It's
I think it might be better to deal with that at 2 o'clock. How are you
very
doing
happy.
time-wise?
Very happy to do that. I'm doing better than I thought I was doing yesterday afternoon, so I'm on track.
Good.
What large baby?
It's 3:15.